So for our panel on the question of how well did our election systems perform in 2012, I'm Joey Fishkin. We have four great panelists, all law professors. Mark Rosen at Chicago Kent, where he studies and writes about both election law and conflict of laws and constitutional law. Rick Hasen, professor of law and political science at UC Irvine, who wrote the book The Voting Wars from Florida 2000 to the Next Election Meltdown. Ned Foley at Ohio State Moritz College of Law, who's also the director of election law at Moritz. And Heather Gerkin at Yale Law School and author of the Democracy Index, who also moonlights as secret weapon of the Obama 2012 election protection team. So let me turn it over to them.
I'm going to stand too so we can actually see you. So I thought I would kick us off by giving you what amounts to three views of the cathedral. Three lenses through which you can look at how well our election system performed in 2012. And the first is obviously a lens we all possess, which is what the media gave us. I have read it obsessively. The second one is that a very small number of people possessed. I spent 18 hours in the boiler room of the Obama campaign in Chicago, one of about a half dozen lawyers and about 100 staff members who ran the election that day. And because thousands and thousands of volunteers were providing detailed reporting throughout the day, I saw the election scroll right across my screen in real time. Now the final view is the lens of an academic, which is looking at the kind of systematic, aggregate data that is the gold standard among scholars. As some of you know, and as Joey's kind enough to mention, a few years ago I proposed creating a democracy index to rank states and localities based on how well they run their election system. And I've been lucky enough to have spent the last few years with the Pew Center in the States working to create an election performance index, which will be released shortly. So at least for the last two views, I have seen things that probably maybe some of you haven't seen. I might be, if I may quote Jack Rakov, quasi-crypto-authoritative on this question. I actually, every conference needs a t-shirt, Sandy, and I had thought it was going to be, is America governable? Answer no, and then we'd all go home. But now I begin to think that maybe our title ought to be, is America quasi-crypto-authoritative? And I leave you to answer that question. So let's start with what you all know. If you looked at the election through the reports of the media, you'd know one story about 2012. Lines, lines, and more lines. And that story, it seems to me, is skewed in a couple of different ways. So first, we all have the natural human instinct, especially prevalent among law professors, to equate anecdote with data. So most of us, I suspect, at least intuitively, are probably overestimating how bad things were. Most voters in most places had no problems with lines. We also probably think that the lines were endemic to this cycle, but I will just tell you, in 2008, in the boiler room, we saw exactly these kinds of lines. But because the 2008 election wasn't close, because the big story of the moment was the first African-American president being elected, those lines got no press attention at all. The reporting that was misleading in another way, because the lines were just symptoms of pernicious problems that the media did not report and that occurred in many places without long lines. Lines are caused by poorly trained poll workers, under-resourced election systems with too few poll books or machines, outdated registration systems, partisan shenanigans, and sometimes just plain old-fashioned incompetence. And let me repeat, those problems arise everywhere in every election. We saw them in the 2012 boiler room, we saw them in the 2008 boiler room, and the aggregate data confirmed them. But the media doesn't investigate, let alone report on these problems, unless the system breaks down. Unless the election is so close that the margin of victory is smaller than the margin of error, or if the lines actually get long enough for everyone to take notice. So we know about lines in 2012. We know about the messes in Ohio in 2004 and 2000, and we get the impression that those problems are in those places, when in fact the problems exist everywhere and are far more widespread. Put differently, if we depend on the media to tell us how the election system is functioning, we'll only know where the lines are long or the margins are small. And that is like trying to measure annual rainfall based on where lightning strikes. What we really need to know whether the election system is performing well is a measure of annual rainfall. Now, aggregate comparable data, like the one that Pew's soon-to-be-released election performance index gives us, is a measure of annual rainfall. It lets us see how the election system works over time in reaction to policy. It lets us compare how states are doing, how states are even doing it against themselves over time. We don't have to wait for what Rick always calls an electoral meltdown to figure out whether or not we have a problem. And there's a reason that that's the kind of data that is the coin of the realm among scholars. It's dependable, reliable, free from many of the biases that anecdotes or non-systematic data can provide. And my guess is that when we look at the aggregate data, we've only seen a little bit of it so far, we're going to have a slightly cheerier view of how this system is functioning. The rain may be falling, but the sky is not. Early data suggests that 2012 looked a lot like prior elections. That meant that small percentages encountered problems in the polling place. There were machines. The average waiting time, it turns out, was 13 minutes. 1/3 of Americans, as far as we know, didn't have to wait at all. So if the data end up looking anything like they did in 2008 and 2010, where we have a really good read, we know that as a general matter, most voters report relatively few problems with the system. As a general matter, most ballots get counted, and as a general matter, most elections ran smoothly. But the aggregate statewide data also lead us to miss important things, which brings me back to those 18 hours I spent in the boiler room. The boiler room had a clear selection bias, to use the political science term. The Obama campaign was not monitoring random precincts. Its volunteers were working in swing states and in the precincts that mattered to us. But still, the boiler room allowed us to see things that the aggregate statewide averages would not let us see. So first, one got to see what the election system looks like when it's undergoing a stress test. And I'll just tell you, it is not very pretty. In most places, the election wasn't close and turnout wasn't unusually high. It's only when there's a turnout tsunami or an election meltdown that the system can't withstand the pressure that we were putting on it. But there were places where the pressure just got too much and chaos prevailed. Second, just as reporters' anecdotes can blind us to larger patterns, nationwide statistics blind us to locally concentrated problems and burdens that fall too heavily on a predictable subset of voters. In the boiler room, we could see what was happening with the tails of the distribution. We could see that certain kinds of problems seem to burden predictable populations in predictable ways. And lines are the perfect example. In presidential elections, most people won't have to stand in line for a long time, but those who do tend to be in poor neighborhoods. They tend to be in under-resourced cities and counties. They tend to be in places that had long lines in 2008. Third, the nationwide statistics conceal a simple fact, which is how much work the campaigns and civil rights groups put into keeping those aggregate statistics within an acceptable range. Because even though the problem didn't become intolerable, that is largely because the Obama campaign in particular devoted unknown resources into propping up the system. The Obama campaign wasn't just providing water and entertainment for those in line on election day. There was a huge amount of advance work. There was a huge amount of litigation and a huge amount of work done on election day to make the system work. So next time someone tries to tell you what the cost of running elections is, I suggest you also give the Obama campaign a call and ask them how many millions of dollars they poured into the system this year. Finally, national averages don't help us think about the floors, the absolute basic things that every election system ought to do. Even where the system runs smoothly on average, we shouldn't accept the outliers, and it's the outliers that we saw in the boiler room. It is not acceptable when a large number of voters are turned away because voting officials couldn't do something as simple as deliver the right poll books throughout the city. It is not acceptable when polling places run out of ballots, despite every indication that turnout would be reasonably high. It is not acceptable when all the machines in a polling place break down or an election official turns away early voters entitled to vote that day because she was surprised that so many people showed up. It is not acceptable when 18-year-old campaign volunteers, barely shaving at this point, it's not okay when they have to explain to elections officials that no, it's not okay to ask for photo ID when that's not the law. And yes, it is actually illegal to turn away voters who are standing in line in the close of the polls. There are, in fact, some things that are so basic that we should expect everyone to do them. And there are a lot of polling places and even cities and counties that couldn't even execute these basic tasks. We deserve better than that. And that returns me to the media. Their reporting on the state of the election system is inevitably going to be skewed. It tells us about lightning striking but not annual rainfall. But to be fair, it is not fair to ask the media, particularly the depleted, under-resourced, understaffed media we now have. They are not all out on lip tack. It is not fair to ask the media to show us what the academics or even the Obama campaign could tell you. But reporters can give us a sense of the costs involved when the election system falls below the floor. The data, the academics, or even campaign lawyers tell us what to fix, even how to fix it. But without reporters putting a face on those statistics, we never get a sense of what it's like to stand in line for 8 hours unless we actually did it. We're never going to learn the lesson that I think the president correctly drew from Election Day, which is we need to fix that. Thank you very much.
Yes.
Thanks, Joey, and thanks, Sandy, and gentlemen of the jury.
Notice the reversal of the social scientists are. We will come up with a verdict.
Will be a thumbs up or a thumbs down.
Right now?
Your dreams.
Peanut gallery, better than what I'm going to do is talk a little bit about assessing what I've called the voting wars in the 2012 elections. First, I want to talk about the amount of litigation, what it looked like. Second, I want to talk about one of the main features, which is what I would call a Republican state legislative overreach in 2012. And then lastly, the judicial backlash to that overreach. And then finally, I want to look ahead to what I'm calling in a piece that'll be out later today in Slate called The Great Democratic Freakout over the Electoral College changes that might be coming ahead. So first, in some ways, the 2012 election looked a lot like the last 2 elections. And if you take a look at the statistics that I put on my one slide, it may be a little hard to see. I've tried to capture all the election litigation that's going on nationally since 1996. And so if you look at the period before 2000, we had an average of 94 cases a year on all kinds of election issues. Since 2000, that average has jumped to 242 cases a year. So more than doubling the amount of litigation. And 2011-2012 period fits the pattern that we've seen before. There were 298 cases in 2012 compared to 297 cases in 2008 and 361 cases in 2004. Clearly, election laws become part of the campaign's political strategy. And there are a lot of reasons why there's litigation. Part of it is to get advantage. Part of it is we've changed the rules. Help America Vote Act. Part of it is we've changed the technology, which raises new questions. But a lot of it is people are more willing to litigate early and often to try and get advantage and to stop things that are objected to. 2004, a lot of these lawsuits involved Democrats trying to keep Nader off the ballot and some questions about the Help America Vote Act. 2008 saw more questions about the Help America Vote Act, including a dispute in Ohio over the use of voter registration databases that went all the way to the Supreme Court. The litigation in 2012 focused very much on new changes to election rules which were passed by state legislatures, mostly Republican-dominated legislatures. This is different than in 2008 and even 2004, where most of the changes were coming from administrative rules or implementation coming from secretaries of state, who are also partisan. One of the pathologies of the American electoral system is not just its decentralization, but the fact that we have partisans in most places running our elections. But between the 2008 and 2012 election, we saw state legislatures adopting a number of rules, which in many ways were intended to make it harder to vote. For example, voter identification rules, cutbacks in voter registration, particularly third-party registration in Florida, that was a major case, and cutbacks in early voting, which may or may not have been one of the main contributors to the long lines that we saw in some places. Some of these rules were justified on anti-fraud grounds. Not all of them could be justified on such grounds. Cutting back on in-person early voting is hardly an anti-fraud measure. There was at least some evidence this was a concerted effort on the part of the group ALEC and other Republican organizations to try to skew the electorate to make it harder for groups that are likely to vote Democratic to vote. Now, I think the amount of skew that took place because of these rules was much lower than some have said. But I do think some of these rules did make a difference. There's one report, which I think is going to be subject to some scrutiny, which suggests that about 200,000 people ended up not voting, leaving the polls in Florida because of the long lines. I think that number is probably going to end up getting revised, but at least some of that, and also a number of people in Florida that did not get registered because there was a year-long period before the courts had reversed the rules on registration, which were so tough that it made the League of Women Voters stop agreeing to register voters out of fear of being arrested for committing a felony. All of this led to both a public and judicial backlash against some of these voting changes. The public backlash was to be expected. Democrats made claims of voter suppression, a key part of the campaign. You had Obama and Biden and Michelle Obama and others speaking about attempts to steal the vote. Part of what I've seen in the voting wars is that the fight over voter fraud and voter suppression is a means to motivate the base to get people to turn out to vote. What was somewhat surprising was the judicial reaction. And in the past, we had seen on issues like voter ID much more division along party lines. So for example, when back I think it was 2007, when Michigan's Supreme Court considered whether its voter ID law violated the state constitution, the 5 Republicans said no, and the 2 Democrats said yes. And so we saw that kind of split. In 2012, we did not see that kind of split. So we saw 3 judges, Democrats and Republicans, vote to block Texas's voter ID law under the Voting Rights Act, but 3 judges, Democrat and Republican, voting to uphold South Carolina's voter ID law under the Voting Rights Act, although postponing it because there wasn't enough time to get it in place for the election. In some of the cases, I think the courts really stretched the law. This is something that I've debated with Heather and others who were on the Obama campaign team. The Ohio early voting case is a really notable example where Ohio provided, I think it was 23 days of early voting. They sent an absentee ballot application to every Ohio voter. But because of a quirk in how the Ohio Republican legislature changed its rules, and no doubt they did so in a partisan way, there was the last 3 days before the election where only military and overseas voters could vote in person in Ohio, but others could not. And in the end, the Sixth Circuit held that this cutback in early voting violated the Equal Protection Clause. I think very questionable application of the precedents in terms of this. But Judge White, who was one of the judges who concurred in this result, really was much more honest about what was going on than anything else. She didn't even talk about the fact that there was different treatment between the military voters and other voters. She said, look, in 2004, Ohio was a disaster with long lines at the polls. In 2008, early voting was extended. Things looked much better. I don't trust Ohio to be able to run its election fairly in 2012 without this early voting. And so, kind of unmoored, the judges created a backlash. And interestingly, we see Bush versus Gore, the precedent from the Supreme Court from 2000, from the dispute between George Bush and Al Gore over who would be president, had an equal protection component to it, violated equal protection the way votes were being recounted. That precedent has been pretty much dead. In fact, I wrote a piece in 2007 called The Untimely Death of Bush versus Gore. In the Sixth Circuit, in the Ohio early election case and others, Bush versus Gore seems to have been revived. And so there's an open question whether we're going to see a continued aggressiveness by the courts in policing certain overreaches in changes in election rules. We may not see as much of this judicial reaction in 2016, in part because it looks like Republicans have reacted to what looks like an overreach by pulling back. So at first, Scott Walker, the governor of Wisconsin, said, you know, let's get rid of same-day voting, election day voter registration. And then he pulled back. You had Rick Scott distancing himself, the governor of Florida, distancing himself from, well, that wasn't my bill that passed in Florida that cut back on early voting. We need more early voting. And so there's a kind of self-correcting mechanism that may be coming into place. And finally, let me look ahead. The president has now twice made comments about election reform. First in his election night speech where he said we have to fix that, and then his inaugural speech where he said that waiting in line is too long. See, there seems to be some movement towards at least a proposal coming forward from the White House over some kind of election reform. And on Harry Reid's list of the 10 things that they're going to accomplish, campaign finance and election reform is on that list. I think we don't know how serious this is going to be. We don't know what kind of reception election reform might get over in the House, or campaign finance disclosure might get. But I do think that it's on the agenda in a way that it was not on the agenda after 2008. But finally, let me turn to this question of electoral college changes. I understand the front page of the Washington Post had an article this morning about how Virginia is moving towards a change in the Electoral College system. Rather than a winner-take-all, all the states' Electoral College votes going in one direction, what's supposed to happen if this plan passes is that it's done by district, and then the two state electoral votes go to whoever wins more of the districts. And because the districts, congressional districts in Virginia are gerrymandered to help Republicans, this would have led to Romney getting 9 out of 13 of the Electoral College votes if the plan had been in place. First of all, I think it's unrealistic to just look at the Electoral College districts, figure out how the votes would have broken down, and predict what the outcome would be. To paraphrase Donald Rumsfeld, you go into a campaign with the Electoral College allocation rules that you have, not the rules that you want them to be or wish them to be. And if the Obama campaign had to fight district by district, and the Romney campaign had to, we'd see a very different campaign. And I think it's hard to know. Certainly the Republicans would have an advantage if they passed these rules only in states with Republican gerrymandered congressional districts. But I think we don't know exactly what the outcomes would be. But I do think that the same self-interest which impels Republicans to consider these changes to the Electoral College rules also will impel them to decide not to adopt this program. So I'll go out on a limb, even though next week this may make it through the Virginia legislature. I think it's not likely to happen for 3 reasons. First, adopting this program makes states immediately less important. So if you're the battleground state of Virginia or Ohio, you're going to get a lot less attention if all that's at stake is a fight over 1 or 2 Electoral College votes rather than over the entire state's votes. And you're giving up a lot. You're giving up a lot of attention. You're giving up a lot of advertising in the state. You're giving up a lot of things. Second, it makes at least the marginally competitive Republican districts a magnet for Democratic activists. So all those Republicans who are in somewhat shaky districts, they're going to have Democrats going in there trying to get votes there. That doesn't look like it's in self-interest. And finally, it's kind of defeatist. It's saying the Republicans don't believe they could ever win Virginia, so they'd rather split the difference rather than go for this. And so we're looking for states with Republican legislatures and voting for Democrats for president, where there's no realistic chance that Republicans could win the presidential race in that state. And I think the only state that really fits into that category consistently is Pennsylvania, where it's been very tough. But in a state like Virginia, a state like Wisconsin, I think Republicans still think those are competitive. So in their own self-interest, I don't expect this is going to go forward. And so while there's a lot of noise being made, and I do think that making the noise will make it less likely that this happens and could actually help defeat these measures, I don't think it's likely that we're going to see 5 or 6 Republican states, as some have predicted, changing their rules for the Electoral College before 2016. Thanks.
Thank you, and it's great to be part of this. Whoa.
I think you're wearing that mic.
Okay. I was going to try yet another possibility in terms of where to stand, because I am going to be talking about some numbers, but
You have to keep away from that.
I have to keep away from this.
Turn this off.
Okay.
Why don't you stand next to the screen then?
Yeah, there you go.
Now, I'm hoping that people can see these numbers, and if you can't, at least we'll be able to appreciate some of the conceptual points that flow from them. So what this first slide shows, this is from 2012, and it shows the amount of improvement that Obama made relative to Romney from election night, when all the precincts had reported their initial returns, then taking all the way to the end of the canvass to final certification. And so the first thing that you see from these numbers is just how huge that improvement was in the state of Ohio, over 65,000 votes. So what that means is that if Obama had been behind in Ohio by 65,000 votes, he could have made up that difference and won the state without any litigation at all, because that's what happened without litigation this year. So what that means is if Obama had been behind by 70, maybe even 80,000 votes, and Ohio had been the single state left to decide who was going to get to 270, it might have been prudent, even that much behind, to fight for it. that suggests that the margin of litigation, to use Rick's phrase, in Ohio for the 2012 election was around 70 to 80,000 votes. That's a huge margin of litigation, much higher than most of the other swing states, as you'll see from this list. It's also much higher than the margin of litigation was in Ohio back in 2004. There's no way that Kerry could have made up a 65,000 vote deficit vis-a-vis Bush in 2004. The only additional improvement that Kerry made between election night and the final certification was 17,000 votes, a much lower number. So Ohio is increasing its margin of litigation over time, exactly the opposite of what you would think should happen in a state that Nate Silver said was the most likely tipping state in a presidential election. That state is now, seems to be the state most likely to take a presidential election into extra innings by virtue of this canvassing process. So once I sort of realized this potential implication from these numbers, I wanted to look a little bit deeper, and so produced, sorry, there's you see that big significant difference from Ohio. But so here, this column in 2012 is the exact same number in the first slide, but I've gone back to 2000 with all of these swing states to see what patterns we can emerge. And so here at the top again, you can see that this 17,000, that's what Kerry was able to do in terms of a little bit of improvement. The big jump in Ohio is between 2004 and 2008. And what I think is going on there is that Ohio made significant changes in its voting rules in 2005 after the 2004 election. One was to increase the reliance on provisional ballots so that there's just many more provisional ballots in Ohio's elections after 2005. And then the other thing was to expand absentee voting, so there's no excuse absentee voting. Anybody can vote by absentee ballot. The unintended consequence of those changes is just many more uncounted ballots on election night that then move into the canvass, and so they can cause this dynamic. But I actually think the even more important implication from this chart is to look at the 2000 column. So this column over here, it has two features that I think are important. One is the relatively small order of magnitude, and the other is the fact that you see negative numbers. The negative numbers mean that for those states, it's actually the Republicans who are gaining some additional ground or improvement from election night to certification. Absentee ballots are coming in from overseas, military voters, they can make some improvement. Again, the highest order of magnitude is 12,000 in North Carolina, 11,000 in Virginia. Those are much lower numbers than the 20,000, 30,000, 40,000 votes that you're seeing after 2000. These two features of the 2000 numbers conform to what conventional wisdom is among recount lawyers, or was back in the 90s before 2000. And the conventional wisdom was that if you had to be behind by just a little bit if you were going to make up a gap in the canvass or recount. If you're behind by more than 2,000 votes, or a few thousand votes, you're just not going to do it. That's why Nixon in 1960, when he was behind in Texas by 40, 50,000 votes, says you just can't make up that kind of difference. And the other thing that recount lawyers said, well, sometimes Republicans win recount, sometimes Republicans do better in a canvass, sometimes Democrats. It can go either way. There's a kind of veil of ignorance to what the canvassing process and the recount process is going to achieve, if it can go either way. And that, as we've learned in the American Law Institute project that some of us, Heather and Rick and I, are working on, that veil of ignorance is conducive to potential reform. But what's happening now is after 2000, we're losing those negative numbers. There's only a couple of them in 2004, and they've disappeared completely by 2008 and 2012. And again, the order of magnitude is just jumped considerably. So I'm calling this the big blue shift, because this has now become an asymmetrical democratic phenomenon of being able to gain during the canvass and being able to gain big. And I think, again, that has potential strategic implications for how parties think about the canvassing process and the recounts. I mean, I hope not, but I think that's inevitably that the campaigns and the parties are going to kind of internalize this dynamic. And because what this big blue shift shows is it's not a phenomenon unique to Ohio. Ohio may be a more extreme version of this, but it's happening in a lot of these other swing states to a considerable degree. So that's making me think that this is a phenomenon of election law changes that occurred more broadly nationally after 2000. Again, the Help America Vote Act of 2002 introduced provisional voting on a national scale, and also there has been a widespread liberalization of absentee voting rules around the country. Again, maybe a good idea, but the unintended consequence could be this new dynamic. And it's a potentially perverse effect, because again, you think after 2000, the one thing that we would not want is another presidential election going into overtime, and yet these legislative changes are making it more likely in more battleground states of taking us into an overtime situation. But before jumping to conclusions, I thought, well, maybe something else is going on here. You know, 2008 and 2012 were big Democratic years. You know, Obama did well, so maybe, you know, a lot of the blueness of this numbers is just that those were good years for the Democrats. So I decided to go back and look at 1996, a year that, you know, Clinton did well, the Democrats did well, to see if that looked like 08 and 12 or not. So it turns out 1996 looks a lot more like 2000 than it does 08 or 12. In other words, except for Michigan here, which I don't really know what's going on with Michigan, it's kind of bouncing all over the place. You know, the order of magnitude is relatively small in 1996, comparable to 2000, and you see a lot of these negative numbers like you do in 2000. So now I want to expand this analysis, look at more states, more years, but the tentative conclusion just from these numbers is pointing to that we have had a significant shift in our election laws since 2000 that has changed the phenomenon of the way canvassing works, that is causing us to have this new dynamic, this new blue shift phenomenon. And so, and again, it can exist in multiple states. So, you know, now, if the proposal that Rick and others yesterday were talking about, where we change the rules of the Electoral College, you know, this might disagree. But if we think about 2016, with the Electoral College rules that we have in place now, the winner-take-all situation, you can imagine a scenario where the Democratic candidate is behind by, you know, 25, 30, 35,000 votes in many of these states. Colorado, Pennsylvania, Florida, Virginia, even putting aside Ohio, and yet the Democratic candidate would say, you know, if I can through litigation and through the canvassing process make up that difference in all these states, I'm going to keep fighting, and that might get me to 270. And so that's the possibility of going into overtime, not just in one state, but several. And that scenario would look a lot more like 1876 than 2000. And anybody who's closely examined 1876 and 2000 would tell you that 1876 was much, much worse.
Hello. Thanks to Sandy for the invitation, and it's a real pleasure to be here today. So our charge on this panel is to consider how well our electoral system did in 2012. What I want to do is try to present a framework for thinking about how well our electoral system did. And let me get into this framework right now. We have, in the United States, systems of institutions that are created or recognized by the Constitution, three important sets of institutions, two of which are importantly protected by constitutional principles. One of those systems is the Federalist system, the states which pre-existed the Constitution. There's a set of constitutional doctrines that protect the states. There's a set of constitutional norms that federal officials use when regulating. A second governmental system that is created by the Constitution, of course, is our system of national government, and we have doctrines of separation of powers, which also discipline the way that states act and discipline the way that the federal government acts. It seems to me that there's a third other significant governmental system that is both created and recognized by our Constitution, but with regard to which there's been no conscious constitutional protection. The system that I'm talking about is the great system of Republican government, representative government. We, of course, have a system of representative government that's created at the federal level, and we have a system of representative government, or republicanism, that is guaranteed to the states also through the United States Constitution. And just like there are constitutional principles which protect the health of states with regard to federalism, there are constitutional principles that are there to protect the presidency and Congress and the courts through separation of powers. It seems to me that there is a constitutional principle that ought to be recognized that is there to ensure the continued health of our Republican institutions. And so what I want to do is flesh out for you the contents of what I think this constitutional principle is. It's something that I call Republican legitimacy. It's the circumstances that must pertain for the products of representative governments to make legitimate claims on citizens, to require them morally to abide by the laws, even if the citizens don't like the laws. And then I'm going to use that framework of the contents of Republican legitimacy to look at three different phenomena that occurred during this election cycle, and not only this election cycle. So it seems to me that there's two main components of Republican legitimacy. One concerns the way that our representatives are selected, and the second concerns the processes by which the representatives actually make law. And there's a variety of activities or laws or practices that potentially imperil both the first, something I call legitimate selection, the selection of representatives, and the second component, which is the decision-making processes by which the representatives use. And I'd like, through this framework of Republican legitimacy, for us to consider three sets of laws and practices that, unfortunately, in my view, are relatively entrenched practices nowadays. One concerns strict voter regulation and identification requirements that arguably are intended to suppress vote, that very clearly implicates the fairness of the selection of our representatives. The second is partisan gerrymandering, something that was discussed last evening, which also implicates the fairness of the selection of our representatives. And the third is matters with regard to campaign finance, or the lack thereof, and I'm referring post-Citizens United to the role of money and the limitations on campaign finance that Citizens United imposed. Campaign finance implicates both issues of the selection of representatives and also the decision-making process that the representatives use. So it seems to me that there's a fair amount to be concerned about from the vantage point of Republican legitimacy. if we look to our last election cycle. And I'm not going to provide all that many facts because I think most people in this audience already know most of the facts, but there were more than 30 states that enacted voter identification laws that primarily were justified on the basis of anti-fraud in the absence of any real evidence of fraud. We did have that statement by Mike Turzai of the Pennsylvania House. Voter ID is going to allow Governor Romney to win the state of Pennsylvania. I suppose we could parse that different ways. But the point about, although I think it's hard to, but the point about taking, let's say, a Republican legitimacy perspective to thinking about voter identification is the following. It's concerning to me that this concept that we must act to preserve the legitimacy of a Republican government is not it's not something that seems to guide many legislators. It seems to me that the constitutional principle that I'm speaking of is a constitutional principle of Republican legitimacy that, for the most part, is a responsibility of state legislators. It's difficult with regard to voter ID, far more difficult with regard to partisan gerrymandering, to have courts simply try to police these types of malfeasances. And the problem is, if you actually look to what legislators say, particularly actually in the partisan gerrymandering context, they speak as if these matters of voter ID, partisan gerrymandering, are just up for ordinary grabs, hardball, ordinary politics governance. And I'm suggesting that these kinds of rules of the road of our Republican system are not that. They're higher order rules that implicate the fundamental fairness of our Republican system, and I would hope that would guide legislators when they act. Hasn't yet. The hope that legislators would be guided, I think, is not a misbegotten one. When legislators are made to realize that they are undertaking serious constitutional acts, they very frequently rise to that occasion. Just a quick anecdote: in my state of Illinois, we recently impeached a governor, and I think the legislature acted extraordinarily responsibly. They hated the governor, even though it was mostly a Democratic legislature. He was a very difficult person on many levels. But they understood that what they were doing had all sorts of precedential consequences, that it would affect the strength of the governor's office, and I think that they acted in an exemplary fashion. And I would hope that legislators could also act in a more exemplary fashion when they do such things that enact laws that concern the ground rules of Republican government, that implicate what I call Republican legitimacy, if they only realized that what they were doing had these implications. So let me just say a few more words about partisan gerrymandering and campaign finance. So partisan gerrymandering, it seems to me, is it's very obvious why that implicates the fairness of the selection process. There's all sorts of indicia that there's substantial partisan gerrymandering that has occurred, is going to continue, and it's something to be concerned about. As people in this room probably know, there is now 37 states that have single-party control. There's reason to expect that there will be efforts to game the districting process that has all sorts of implications in terms of of who's selected. Of course, one other thing I'll just mention is that to date, pack and crack has been the primary mechanism for partisan gerrymandering. There's a very, very interesting recent piece that was published by Adam Cox and Richard Holden, which has actually shown that there's a far more effective method, which they call matching slices, to partisan gerrymander. And so whereas your ordinary pack and crack can attain a maximum advantage of 57.2% to the party that controls, which means like in the state of California, which has 53 seats, could yield 30 to the gerrymandering party. Under matching slices, you can go from 57% to 69.2. That's a breakthrough, a technological breakthrough, which only accentuates obviously the potential dangers of partisan gerrymandering. Whether that technique can be instituted turns on certain information that the district line drawers must have, but that type of very localized information is only easier and easier to obtain nowadays. In any event, it seems to me that with the framework of Republican legitimacy, there's some significant concerns that we should have if we look back to the election that just passed. Thank you very much.
Okay, so I'll just ask a question or two and then open it up so we have as much time as we can for the whole group. I wanted to ask all of you about, in the spirit of the sort of general themes of the conference, the politics of reforming or improving our electoral system a little bit. And just to make it as pointed as I can, is there an election reform agenda that today would be helpful and would not be perceived by the Republican Party in particular as a power grab by Democrats? Is there is it sort of all partisanship all the way down at this point? Or is there both an agenda and then also, I guess, any institutional starting points for an agenda that is not just partisan?
Something actually, I go talk to reform groups all the time. They're called GUGUs, the Good Governance Groups, there's often a quality to their reform proposals, which I call the just add water problem. So they get up and they announce what we should do, and of course it sounds great, and it's never going to happen in a billion years. And so these poor people spend their lives, their entire lives. I don't know how they get up in the morning because there's no chance at all that anything that they want is going to happen. So my view is, the election reform process is slated against reform because the people who know the most about reform and care the most about reform are the people who oppose reform, that is, legislators. They would all like the election system to look exactly as it did 4 years ago with exactly the same electorate showing up because that's how they got elected. So I think that the way to think about it, and something I've written about, is to think about it as a here to there problem. We all know what the problems are here. We all know the problem, what we want for solutions there, or at least there's some reasonable consensus about the basics. What we don't know is how to get from here to there. And I think it's time not to think bigger but smaller. Sorry, Sandy. Where's Sandy? Sandy's going to call me an ameliorist, which he's recently done print, and my parents actually thought that was a very bad word. We need to think like ameliorists. We need to think about small solutions, interventions in the process that are going to help make the reform terrain more receptive to reform. So one of my ideas has been to create a democracy index, which would rank states and localities based on how well they run elections, and indeed we are going to actually very soon have a ranking of states and localities based on how well they run elections. And what has been remarkable to me about the couple of years that I've spent involved in this process is how powerful a weapon that information is. So it's a powerful weapon because right now Americans have no idea whether their system is working. They have no idea whether the states are doing better than others. But it's also possible because it's actually targeting a group that is susceptible to reform, which is election administrators. So it turns out the other people who know most about reform and care the most about reform are the election administrators. And they care about their professional status. They really care about where they rank on that ranking, and they are actually driving reform. We've seen it even with small sort of sets of data that have been released. Those numbers matter, And they matter for the same reason that we all suffered in high school, at least those of you who are academics, it was peer pressure. So peer pressure produces Britney Spears and Justin Bieber and horrible things like tongue rings, but it also produces professional peer pressure, the desire to do well compared to your peers. And professional peer pressure is a powerful force for reform. So I, with all due respect to the election reformers, I would like to see small rather than big, but with an aim to imagine the small reforms that make big reform more likely.
So if I can pick up on that, I've thought about this a lot because thanks to Heather, who wrote me into this American Law Institute election reform project, which I'm very grateful that she did, but the challenge there, the ALI wants to have a set of proposals that are genuinely bipartisan or impartial. So is that feasible? Well, we pulled together a group of advisors from both sides of the aisle and also election litigators who do this for a living, and their recommendation was actually to start at the back end of the process, the recount process, the canvassing process, precisely because of this veil of ignorance point. They know ahead of time whether they like voter ID or don't like voter ID, but they've been through enough recounts where they'll argue whatever position, if their candidate is behind, it doesn't matter whether they're Democrat or Republican, they'll argue the set of rules that are better for if you're behind. And if you're ahead, you argue the opposite. And if you're in Minnesota, you argue whichever one, it depends on which day of the week, whether you're ahead or behind. In other words, lawyers can switch position on a dime, and they did. So they said, so from an ex-ante law reform perspective, tackle that issue, see whether you can develop some goodwill and capital, and then maybe tackle some things like early voting and so forth, some small-scale stuff. So what troubles me most about the data that I presented is it's undermining that veil of ignorance premise that might lead both sides in a bilateral agreement to say, let's get a good set of recount rules ex ante, because we don't know what world we would prefer ex post after election day. So that's why I think this is really troublesome. On a slightly more broader point, and to tie it to last night, philosophically, I've always thought, and I deeply believe, that democratic politics is either a two-party system or a multi-party system, which means that the parties in the system all the parties must perceive that the rules of political competition are fair. And so that a well-designed system would allow them to be robustly partisan and fight, as long as the parameters, the rules of the game, are fair to all the participants. So that would mean that if either, and just stick with two parties for a moment, if either party genuinely thought that the rules of the game are unfair to their perspective, that is itself a moral reason to think that there's something wrong with the rules, because their position, even if you from the opposite party kind of disagree with their view, the fact that they don't think that the rule is fair needs to be honored. And so both parties need to think that it's fair, and I've wanted that kind of spirit to be able to help bridge perhaps some of the divides on some of the most contestable issues like voter ID. I know it's naive, but the thing that I worried about is if Tom and Norm are right, at least in part, then if one of the two parties doesn't accept the premises of the system to begin with, and I'm not saying I'm there yet, and that would also have implications for the ALI project and other reform efforts. In other words, if either side says, we don't accept the premise of fair competition, then I think we're in deep trouble.
Thanks, Ned, for making me even more pessimistic about that. On the federal level, I think it's going to be very hard to get any kind of legislation that would mandate further national standards at this point. If President Obama wants to make fixing long lines a priority, as he's now said twice he wants to do, I think it's much more likely to come in the form of carrots rather than sticks. And if you think about the different veto gates, you've got Candace Miller, who's now the chair of the House Administration Committee and a former Secretary of State of Michigan, who has already said, She takes a federalist view, and thinks this is more appropriate for the states than for the federal government. I don't see any way that anything like that gets through the House, unless it's just some kind of grant or something that is not going to be obligatory on the states. Something broader, like universal voter registration, I think is not at all in the cards. Even what reformers who want to move towards that are calling voter registration modernization, so it doesn't sound like universal voter registration, is not getting any traction, even though reformers have been pushing that for a number of years. On the campaign finance side, on the federal level, it's possible there could be room for a compromise that would trade better disclosure for a loosening of limits, either on individual candidates or on political parties. I think everyone recognizes that Citizens United has strengthened outside groups. Candidates and parties want more control. Republicans might be willing to trade some of the contribution limits for give disclosure in order to get loosening contribution limits. I've heard some noises like that. I don't know what's going to happen. On the state level, I think reform is much more likely. And so we see in a place like Florida, even Governor Scott has come around and says there's a need to make changes. And that's because of what Heather talks about, performance outcomes. People can see on TV, they see the voters in Miami wait until 1 o'clock in the morning to cast their vote. I remember somebody was voting while the president was giving his acceptance speech. That much of a problem causes there to be change. Plus, there's partisan fomentation. So we just had, when African-American legislative leader in Virginia went off to President Obama's second inauguration, you had the Virginia legislature coming in to pass redistricting to help Republicans. So there'll be election reform, there'll be election changes, it just might not be the reform that election reformers want to see.
I just want to say that to build on Bill Galston's point, I think from the other day, there needs to be a public demand, and public norms and expectations can actually sometimes shift very radically. I just want to remind everybody that a few months before the passage of the 1964 Civil Rights Act, the popular consensus in Congress was that public accommodations provision could not be included. It was just going to be left with the states. Public norms radically shifted, and we had inclusion. And so, if the system breaks down, there can be desire. I don't want the system to break down, but there can be substantial norm shifts which Congress responds to.
Okay, well, I may jump back in, but let's bring some questions in from. Let me start with Bruce.
So I agree with Ned that the big shift is troubling, the blue shift, right? And I want you to spin out your pessimistic scenario for all of us, because I think it is possible that this is where it's going to go. So the implication is that there are more gains for Democrats, possibly because of HAVA or provisional votes or loosened absentee ballots. So the first reaction will be what we're seeing already, what Rick was talking about, which is the legislative reaction. And then we get to Rick's point, so what does the court do then if it's a legislative reaction with Republicans trying to restrict these early voting opportunities, et cetera? And then what Rick says is, well, the court's kind of found a lot of ad hoc reasons to intervene in this last round, but the only hook we really have that's substantial is the Bush v. Gore equal protection hook, which very clearly is a hook that precludes any kind of across-the-state uniformity, but was at least an opening for within-state uniformity. So is there a role for the court that isn't just completely ad hoc to, in any way, intervene in this and to, in the interest of sort of basic electoral accountability and fairness? Or are we simply in a legislative struggle where it's whoever has the upper hand, and hopefully it'll all balance out across states?
Well, I guess one thing I'd say is that what these numbers do is represent risk. They don't necessarily represent calamity. So it's quite possible and maybe probable that we could see a series of presidential elections for another 100 years without the risk, of the 500-year flood hitting, so to speak. And that would, the vulnerability would be in the system, but it wouldn't come to fruition. The other thing that should be true, and this is a relationship between Rick's slide and these numbers, is in down ballot races, we ought to see, I haven't looked at down ballot numbers, but this phenomenon should be playing out there, and playing out in races where it has consequence, and where the decision to pull the litigation trigger is more realistic. So we should see increasing, Rick's numbers should be going up as a result of this phenomenon. Now that, in a sense, may be a bad thing, but we don't care if, local mayor's races or city council races are caught up in litigation. I mean, that's not a national calamity. And one value of litigation, actually, is it does take issues off the table. I mean, to the extent that you don't have legislative change, but so the statutes are the same, and whether you count this kind of provisional ballot, that gets definitively answered in a Cincinnati judicial race. That answer applies to a presidential election or a gubernatorial election as well. And so I have some other slides which I won't get into, but the story from 2012 is not all bleak. I mean, some numbers of categories of uncounted ballots went down in Ohio as a result of litigation that occurred prior to 2000. And so, we're living on borrowed time, but we may have enough of it such that we can take some of the risks out of the system through litigation in down ballot races. So, there's probably more to say on that point, but I think that is hopefully a relevant response.
I actually think the risk is higher than Ned says. I told Bruce that's going to be a moderator on this panel, but when I look at those numbers, at least when I looked at those numbers when I was inside the boiler room, there's two kinds of calculuses. One is whether the Democrat wants a recount. And of course, any Democrat who's got 66,000 votes to pick up is going to want to recount. To fight the canvass. But if you're a Republican, imagine you're Carl Rove and you're on Fox News, and you know that the Democrats are going to win without question. Obama's going to win without question in Ohio, but you think it comes down to Ohio. Imagine that. You would still contest Ohio. You contest every one of those 66,000 votes just to crap on the win and make it look illegitimate and rile up your base. And you'd be in an incredibly long process for counting those canvass and a recount, which would still result in the Democrats getting a huge number of those votes, but you'd end up, I think you'd end up basically crapping on the win. So the incentives run really in interesting ways if you know for sure, even if you're on the other side. Now it turns out, the Republicans actually didn't have any good numbers. So I don't want to suggest that Carl Rove had this in mind. It turns out he didn't know what he was doing because those numbers were so terrible. But we knew this in the Obama campaign. What we knew that Rove didn't know was that we were also going to win Virginia, Florida, and Colorado because our numbers were so tight. But I think that over time, if it's down to one state, both sides actually have a real reason to think about those numbers, and both sides have a reason to fight it. And so that makes the risk of litigation even bigger, I think.
I could just play against type and be a little more optimistic than that.
Rick, you're never more optimistic.
Yeah. One of the cases, besides the early voting case, that went to the Sixth Circuit that relied on Bush versus Gore, was this case involving provisional ballots cast by voters who, they showed up at a polling place. Turned out there were different precincts in the polling place. They were sent to the wrong table to vote. And under Ohio law, that vote wouldn't count, even though the poll worker was responsible for directing them to the table. And you had a very conservative panel on the Sixth Circuit unanimously say that this violated the Constitution, that someone will be disenfranchised because a poll worker literally could not tell you that the number 798 was an even number. There was testimony. A poll worker thought 798 was an odd number because 7 and 9 are both odd, and 8 is even, has more odds than even. And this was the cause of the disenfranchising error.
You are impugning my state.
So this ties in with Heather's point about peer pressure. I don't see, unlike things like cutting back on early voting and enacting voter ID, I don't see a partisan benefit to Republicans to have a large number of provisional ballots. In fact, I think they have an incentive, professional incentive, to cut back on those provisional ballots. And I think Husted, for whatever you think of him, he's trying to be add more professionalism to the system. And so I think when these numbers start getting out there, there's going to be a lot of pressure to get the number of provisional ballots down. And Ohio, if they fix their registration system, which is a disaster, and they fix their rules for absentee ballots and all of these things, the numbers would go way down. So I think between that court decision and the professional norms, I think there's actually reason to be more hopeful about the specific question of provisional ballots.
John Rowland, Constitution.org. I was the only nonpartisan intervener in the last 2 Texas redistricting cases with a proposal to take human beings out of the map drawing process and turn it over entirely to machines drawing maps at random. This proposal was opposed by all the other parties, and as it was explained very well by then Solicitor General Ted Cruz, he admitted that mine was the statesman-like solution. It addressed the concern of Justice Kennedy in the Jubilee case, but the Republicans wanted the power and the Democrats wanted the issue. And it might also not pass pre-clearance because it might dilute minority opportunity districts. Recently in Virginia, we've seen the Republican legislature gerrymandering in favor of Republicans by creating a minority opportunity district, which may now be entrenched by pre-clearance if any attempt were made to reverse that gerrymandering. So we have a lot of perversities in the system, some of which need to be addressed legislatively, but in the case of the intervention, such as mine, if I had had a little bit more political clout behind the position I was advocating, it's possible that my proposal might have made it to the Supreme Court, and we wouldn't be having to have this conversation, at least about congressional districts.
Just by way of a response, having done redistricting work, there's another reason to reject a proposal, which is it's actually not going to work. And I think that Justice Kennedy would get that if you started briefing it. And the reason is simple. When I was doing redistricting for the Democrats, when we would go out drinking at night, we'd fantasize about all the things we wanted to do. And one of them was to program the computers with the kinds of criteria that would help the Democrats. The Republicans can do the same thing. In fact, some people think that the computerized redistricting favors Republicans just by virtue of the way that they're distributed. But both when you think about minority voters and partisan fairness, random districting doesn't generate the kinds of things that you wanted to generate. It is a democratic judgment as to what you need to balance in thinking about redistricting. It involves all sorts of compromises that cannot be reduced to a simple one person, one vote, make the district square rule. If we were to do that, we'd compromise a lot of the things that we really care about, including the Voting Rights Act. So I'm not a fan of partisan redistricting. It's not that I think that that's the solution to these problems, but it is a mistake that is common, I think, but it's a mistake to think that that's going to work because someone is choosing the criteria to program the computer, and there's a set of values that the computer can't measure for us, which are the trade-offs involved in thinking about partisan fairness and racial fairness when each district.
And beyond that, there's a very interesting study that Justice Breyer actually cites to in the Vive case, which indicates under many conditions, completely random districting generates a system where very small preference shifts among citizens and districts has radical implications for representation, Republican or Democrat. There's strong normative reasons for opposing such random districting, even if you were able to strip out those sorts of backdoor preferences. I think there's fundamental problems with single-member districts, and I think that the kind of idea that Sandy mentioned the other night, which is going to larger at-large districts with a degree of proportional PR there's much that merits that, or at the very least merits much more serious attention than we in the United States have given.
If I just, I think the real interesting story of the last round for districting is the rise of these citizen commissions. The example in California, the example in Arizona, and I know Bruce and others are still evaluating the effects of this, whether it actually improved competitiveness. I was just surprised that this kind of Rube Goldberg-esque machine in California actually produced a plan that got support from a majority of Republicans, Democrats, and independents on the commission, and that was able to get through a litigation challenge and actually produce a plan. And so I think that's a different kind of randomness in that you don't know what you're getting with citizens chosen in a semi-random way, but that still allows the human element, as Heather said, to balance these kind of democratic interests. And I think that's got a lot more promise than I thought it did a few years ago.
So Steve, picture.
I want to indicate to Professor Foley, I disagree with your premise. I think that most of the numbers are a result of the ordinary canvassing process. They're not the result of recount requests or election contests. Professor Rosen, the biggest difference that I've seen in the legislature, the redistricting of Congress and the state houses, is that the members of the state legislature are not reluctant to partisan gerrymander congressional seats. But once you have to deal with the man or woman across the aisle, it's difficult to do it at the state level. And so you'll see something like the delay redistricting in Texas or the one suggested in Virginia, but you seldom see that at the state level. At least I think there are some forces affected at the state level. On the other hand, you'll see more incumbent protection in the state redistricting. And as to the Citizen Commission, for your information, Austin just adopted the Citizen Commission patterned after California. There are 3 cities now nationwide that have citizen commissions. A few more than that, but 3 out of the top 50. San Diego, Austin, and Minneapolis. So there's St. Paul and there are a few others, but they're out of the top 50. So I do agree with Rick that the Citizen Commission is a very, very positive development, particularly at the local level. Thank you.
Just to clarify, I'm sorry if there was confusion. These numbers are not derived from recount or litigation. They are the numbers that exist through the normal canvassing process. The point was that the nature of the normal canvassing process has dramatically changed since 2000 by virtues of new features in the system. The only numbers on this chart that were affected by litigation that I'm aware of is the Florida 2000 number itself, obviously, and then North Carolina 2004, there was litigation in a non-presidential but statewide election that would have affected, the final certification of the presidential numbers as well. So these are canvassing numbers in the absence of post-election litigation.
There was no litigation. There was no change as a result of the litigation in Florida, just to the recounts.
Okay, I think John Forty in the back, is that?
So first, if I heard you right, Heather, drinking while redistricting, you are not an amelioratorist, so.
After redistricting. You need to drink after redistricting.
I had a sort of trying to pop the consensus bubble question a bit. So if you think about the biggest issue that we talked about in the election law world in 2008, 2012, it clearly was Republican changes in election laws and more specifically voter ID. And I've been one who thinks that on the Republican side, the voter integrity side, it's probably not the most important thing, and the form doesn't fit the type of fraud it really is supposed to cure. But on the other hand, have we reacted overly strongly on the other side? 2 ways. One, a lot of these court cases, courts that have struck down laws really probably just delayed a lot of these voter ID laws. I guess I'd like your opinion to think if we aren't going to see lots of some of the laws that held up, like South Carolina, which will go into effect, and Pennsylvania, which might, and others be ultimately go into law, plus other states that may be passing them. So we may end up with what Rick's described in voting wars of kind of red state electoral laws and blue state electoral laws, different types of priorities in both states. And then secondly, I guess I wonder whether we didn't overstate some of the access concerns about voter ID laws. We certainly don't have full data on this, but some of the states that did have strict ID laws saw very small numbers of provisional ballots cast because we didn't have ID, and then some of those even were counted in the hundreds, not certainly in the thousands or tens of thousands or millions, as the Brennan Center report was hinting at. So I think there are a lot more important things in the election law world than this on both sides, but do you think we've overreacted against voter ID, both in the court cases and in the actual outcome of what happened?
I think we're going to get more states with voter ID laws in place in 2016. Pennsylvania, it looked like the entire Supreme Court of Pennsylvania was on board with a voter ID law so long as it could be rolled out in time. You mentioned South Carolina, that could be rolled out. Wisconsin, two very liberal Democratic judges put a hold on that law for 2012. That's going to get appealed to the state Supreme Court. The state Supreme Court is now 4-3 Republican. There's going to be an election there, so it might be 4-3 Democratic, and the vote might split as it did in Michigan on party lines on these things. So I think you're right that we're going to see state-by-state differences. I also think you're right that while some Republicans who strongly supported voter ID did so without any proof whatsoever that these laws stop any appreciable amount of impersonation and fraud, which happens almost never, Democrats, or those on the left, vastly exaggerated the extent to which these laws would disenfranchise voters. Now, you can't just look at the number of people who showed up to vote without ID, because if someone lacks ID and they know they can't get it within 10 days, why would they bother to vote? But the fact is that in a lot of these cases, it's very hard to find plaintiffs who, one, want to vote, two, lack the ID, and three, can't get the ID. This is much more about voters for whom, or casual voters for whom it's going to be very inconvenient to get the ID, and it is about people who would literally be disenfranchised. And the line is how hard you have to make it to vote. And my position is that if there's a good reason to impose this, then it makes sense, but not to put the burden. So I do think there's exaggeration on both sides as a way of getting the base excited. I have examples of both sides using voter ID for fundraising appeals, stop them from stealing the election. Both sides said that. But I do think it's been exaggerated.
Yeah, I just wanted to add, and I just read Rick's really interesting paper on this topic and about the sort of the shift of courts. At least if you were guessing before the campaign whether the civil rights groups in the Obama campaign would win all the suits that they won, I think the answer would be absolutely not, no chance at all. They won all that stuff that they, if you predicted in advance, wouldn't have won. And I think that in some ways it's related to the highly polarized debate about this stuff, which is that they politicked it. The Democrats and Republicans both politic these issues. We now are at a point where one side shouts Jim Crow and the other side shouts, fraud, and it's as illuminating as the taste great, less filling debate. But the courts heard it, and I think that if I were to make a prediction about what happens going forward, is I think that the courts have their antenna up to figure out if there's a reason to do it. If I were to, Rick, I read your paper, here's my comment. If I were to think about what unites all of the cases, the voter ID cases and the military voting case and everything else, it's that what was going on in those cases was the courts were asking, do you really have a reason to do this to the state? And the state, in part through incompetent lawyering, sometimes because they didn't actually have a good reason, would not come back with one. So my guess is that, if I would like to see where the law develops, is that we require the state to have reasons, and not the sort of reasons that you get from lawyers. Rational basis scrutiny, for those of you who are lawyers in the room, is what happens when the law clerks and the judges make up a reason on behalf of the state because the state is too witless to have come up with a reason on its own. That's rational basis scrutiny traditionally. But actually, I think that what you are getting in these cases, although they're nominally rational basis scrutiny, is they're looking a little harder to get it. The other thing I'll just say, John, is since you're the person who isn't, you know a lot about this debate, if I had a compromise on the voter ID question, because I do believe that not the Republicans who pass the laws, but sort of Republicans like my parents do think genuinely that this is the way to combat fraud, and they are good and decent people with good and decent intuitions about it, is that the real compromise is early voting. Because early voting is, the real place that you see fraud is absentee balloting. So that's the problem. That's where all the fraud happens. That's where all the risks are. And yet people like absentee balloting because it's so convenient. That's why, in part, why we see some of these numbers, right? Absentee balloting, all these things are all really easy to do and everyone likes it. Early voting gives you the convenience that the Democrats want, and it gives you the security that the Republicans want, because early voting is very secure. So that would be my compromise. Now that is not going to happen, but it does strike me that if I were running the Democrats' campaign, I would tell them that that ought to be the response every time they get the fraud claim.
If I can I just jump real quick in? I mean, I'm a big fan of early voting and not vote by mail for the exact same reasons that Heather did. But I do think the voter ID issue is a very good case study for whether our system can compromise or not in the way that Dennis and the earlier panel this morning talked about. Because I do think if both sides approach that issue in a spirit of compromise, there would be ways to kind of think creatively and outside the box to do that. Rick has suggested some, the use of electronic poll book technology could give you a system where it's not the voter has to bring the photo, but the photo exists in the poll work and in the poll book, and the voter only has to bring their face, and then the poll worker can kind of look at the book and say, oh yeah, the digital picture in the poll book matches the face that I see. And I was encouraged that Nevada's Secretary of State has kind of floated a proposal that's along those lines, and he's of course been attacked by it. And this may be cynical, and I usually don't want to be cynical, but I suspect that Rick is right that both sides have moved away from seeking compromise on this in order to appeal to the base and do fundraising, and so there's a kind of dynamic, and the permanent campaign causes it to be in the party's interest, in both parties, to not seek compromise.
I should point out there's an excellent book on early absentee voting written by John Forty. Just asked the question.
We haven't heard anything yet about paper trails and real recounts. Who cares about the hacking of electronic systems and all? I wonder if the panel knows anything and can speculate usefully about that relevance.
Yeah, I mean, it's another lurking issue in the system. And if my memory serves, Pennsylvania is a major presidential swing state that does not have any kind of paper trail associated with its electronic voting machines. So that risk. There's a bunch of different risks that are there. I think that there's something of a consensus among people who look at this that if there's one major Achilles heel in our system, it is the provisional voting process. Even though that it was introduced for good, well-intentioned reasons to give people an insurance policy in case against disenfranchisement, the vulnerabilities of a meltdown. If you had to pick your likely source of a meltdown, I think at the moment I would say that more than electronic technology.
Yeah, I think it's clearly still out there. The black box people are at work, and you saw it even if anyone was obsessively, compulsively on the media, checking the media on election day. There were a bunch of YouTube videos circulating of machines that were flipping a vote. So it turns out the Obama campaign actually had an entire group of computer scientists who were sitting in a room checking all these. And it turns out most of them were just calibration problems, which are very typical. And so it didn't happen in this election as far as everyone knows. But the level of paranoia about it is so extreme that I know that anyone who comments in the newspaper always worries you say one thing about this and you're going to get 1,000 email from all the people who think that Ohio was stolen in 2004 and that it's all about Diebold and it's evil Republican conspiracy. No one in the academy, I think, really believes that. But it's definitely out there, and if it were close, you could easily imagine the kind of that's where there's a paranoid right and a paranoid left, and that's where the paranoid left usually puts its arguments.
Yeah, and I've seen there's this group called the Election Defense Alliance, and they claim that there's a subtle red shift that's in the software of the machines that count the optical scanners. They say no one can say with 100% certainty that 97% of the machines, this is a quote from them, are flipping the votes, but what evidence exists they are not? So there is a level of paranoia out there, but in my book I say that even though I think these claims are unjustified, and all of the negative comments about my book on Amazon are all from the left paranoid extreme side. We need, whatever system we use, whether it's electronic or not, it needs to produce a piece of paper. And the reason it needs to produce a piece of paper is not necessarily because the technology is bad to count the votes, so it's going to be inaccurate, but because in the event we have a close presidential election or a close state election, the losing side is not going to trust the outcome without a way to recount. So just trust me, it's in the machine. The polling shows, if you look at people's confidence in the fairness of the electoral process, if you were on the losing side, you were much more likely to say that the system was run in an unfair way than if you're on the winning side. So if my guy won, it was fair and square. If the other guy won, it was a ghost in the machine.
Bill Dawson.
Well, this is not a question so much as an observation. For those of you who were here last night, and of course all of you who can hear me are here now, the difference in tone and analysis is really striking. You know, a dominant theme last night was it's one party's fault, predominantly. But what I've heard from this panel is a series of symmetry arguments. And Heather just said there's a paranoid left and a paranoid right, but each of you in different ways has made a version of the symmetry argument as opposed to pointing the finger at one party or the other. Am I mishearing this, or is that a fair characterization of this panel?
I think it's a fair characterization, but maybe because we hang out in election circles all the time, and what you begin to believe is that, sure, Republicans are doing stuff now because they are in power, and the moment the Democrats are in power, they're going to try to do a lot of things as well. Now, I have a normative take on whether some of these are good things or bad things. I'd like to see early voting and not photo ID. I have lots of views on it, but I think there is a way in which we are too quick to, in the academic world, to subscribe to a certain set of progressive views, and that it's occasionally useful to recognize the good faith of the other side. So yeah, I have a lot of quarrels with Republican parties, and I think in my household, my kids actually think it might be close to an epithet based on the way my husband and I talk. But I also think, you know, that we actually should acknowledge that this is a moment in time, and parties change, and people change, and some of the finest people in the election, in the reform movement, along a variety of dimensions, were Republicans. And just because the party is where it is now doesn't mean it's going to be there forever.
In my book, I tried to reject this false equivalence, and I say that Republicans are more to blame for what's happened since 2000 with changing election rules than Democrats. Both sides are to blame, but Republicans have pushed further to try and change the electoral rules. But if Republicans are trying to make it harder for Democrats to vote, Democrats are trying to make it easier for Democrats to vote. So you see states like California adopting election day registration. And so they can take the high road and say what they're trying to do is to enfranchise more people, but it's also in Democrats' self-interest. And so I think that you have to put it into that context.
Well, Bill, I think you were right last night to emphasize the historical perspective. And one of the things that I was thinking, as listening to last night, as an example of Democratic Party impropriety or lack of fair play was the so-called Bloody 8th Indiana congressional recount in the 80s, where I think the Democrats did not play in a spirit of fair play. So if you go back in history, before 2000, you could see bad conduct in a bilateral or symmetrical way, and what we want is good conduct in a symmetrical way.
All right, we've only got a couple minutes, but given that where we seem to be ending up, let's let Norm say.
I've long favored a separate federal ballot. You get no butterfly ballots, no more than 3 contests. You eliminate most provisional ballots, at least those that are caused by people who might show up at the wrong precinct. And I wanted to get some reactions.
Yeah, it's a great idea. The other thing is you actually have people who know what they're doing designing the ballot. So oftentimes a lot of the problems that we see, including the infamous Palm Beach ballot, were designed by people just who had no expertise whatsoever. And the one thing about centralizing is that you can actually put some money into it. Because ballot design is it's actually a developing field. It makes a huge difference in terms of the accuracy of the vote. And it would be, I think it's a great idea. I'm happy that you're going to spearhead it through Congress.
Okay, well actually on that note, I've been told to keep us strictly to time, so let's thank this excellent panel. I've also been told to let you know that both sandwiches and Larry Lessig's famous slideshow are going to be waiting for you in the auditorium, so please make your way there in an expeditious fashion.